Ladies and gentlemen, welcome back to the Indie Zone. My name is Kathy. Today, the 5th of February, 2026, the defendant, Ashley Guillard, filed motion to dismiss the federal court case styled as Rebecca Schofield versus Ashley Guillard. It was a multiple page document. It's document number 117 in the Idaho 4 federal lawsuit. And her grounds is lack of subject matter jurisdiction. She is challenging the federal court's authority to enter enforceable orders in this case and to preside over the case. It is entitled Defendant Ashley Guillard's Memorandum in Support of Rule 12b-1, Motion to Dismiss for Want of Subject Matter Jurisdiction. Rule 12b-1 is the federal rule of civil procedure where a party seeks the entry of an order that the court lacks the authority to sit in judgment of the case. The introduction to this document reads as follows. Defendant Ashley Guillard respectfully moves the court to dismiss plaintiff Rebecca Schofield's complaint for lack of subject matter jurisdiction pursuant to Rule 12b-1 of the Federal Rules of Civil Procedure. It is legally certain that the plaintiff cannot recover more than $75,000. What this refers to, ladies and gentlemen, is that in this otherwise state case for defamation, in order to invoke the federal court's jurisdiction under diversity of citizenship, which is what Schofield, the plaintiff, did here, she must plead and prove 2 points: that the parties are citizens of different states. She has pled that Schofield is a citizen of the state of Idaho, while Guillard is a citizen of the state of Texas. But beyond that, there must be $75,000 in damages, exclusive of interest, attorney's fees, and costs. So Schofield has got to show that she suffered at least that jurisdictional floor of $75,000. And this is the point that Guillard, the defendant, is coming out of the gate challenging. The introduction goes on. First, the plaintiff has not suffered reputational harm, has not suffered loss of work, and has not suffered admissible mental harm that is caused by the defendant. Additionally, plaintiff Schofield, along with Rebecca Bond, M.A., and Rebecca Talbot, fabricated witness testimony, medical records, and evidence to falsely claim damages in the amount of $1.8 million. The nearly $2 million or more that the plaintiff in docket item 12 asked the court to award her more than she requested is not made in good faith. Lastly, plaintiff does not have sufficient, clear, and convincing evidence. That's the evidentiary standard that must be met here, ladies and gentlemen. It's not preponderance of the evidence. It is clear and convincing evidence, which is a higher evidentiary standard than in your typical civil litigation. She's saying here the plaintiff does not have sufficient, clear, and convincing evidence to prove an award for punitive damages. The plaintiff lacks subject matter jurisdiction pursuant to 28 U.S.C., that's United States Code, Section 1332. The court must dismiss in capital letters the plaintiff complaint for want of jurisdiction. Now, I want to point out that we had reported recently that plaintiffs' two witnesses, Bond and Talent, that are referred to here, are precluded at trial to testify specifically in this case as to damages because the defendant in quite a remarkable ruling, in my opinion, for a pro se defendant going up against an experienced law firm like the law firm here that represented the media coalition in Idaho versus Koberger, to be able to knock out that testimony from the case at trial is remarkable. But that's exactly what the judge did. He granted in part the defendant's motion to do exactly that. While the two expert witnesses can speak generally, they cannot speak specifically in this case as to damages. We are expecting a very vigorous opposition to this motion to dismiss. Please stay tuned for further developments as they arise in the Idaho 4 defamation case. Until next time, this is Kathy. Thank you for joining us here today.